Welcome to the 2020 Virtual Civil False Claims Act and FCA Enforcement Institute, sponsored by the ABA Criminal Justice Section. This session is entitled State FCA Roundtable. Before I introduce our panel, we would like to take a moment to thank our sponsors. Cohn and Colapinto LLP is the supporting sponsor for the 2020 Virtual Civil False Claims Act and FCA Enforcement Institute. Moderating this session is Robert Patten. Robert is President Emeritus of the Taxpayers Against Fraud Education Fund. Robert, you may proceed with the program.
Thank you, Daniel. As Daniel so elegantly put it, I am the former president of TAF. The conference materials inadvertently contained an older biography for me. Many of you know that Jeb White has resumed the position of president and CEO of TAF and the TAF Education Fund. Jeb, in his previous tenure in that position, was one of the coordinators of this conference, along with Dan Anderson and Jack Basie. And speaking of Jack, I would be remiss if I didn't join the chorus of condolences for Jack's recent passing. In the course of my lifetime, I've had just a handful of friends whom I would describe as larger than life, and Jack was certainly one of those. He had a combination of intellect and tremendous energy and knowledgeability in this area of the law that was truly something to behold. And I got to know him as a speaker at this conference over the years, and as a co-panelist with Jack at the annual ABA Healthcare Fraud Conference over a number of years. He made, over the course of his career, an extraordinary commitment to continuing legal education, and this conference really was his baby. I used to joke with Jack that the only thing that we agreed about in false claims law is how to pronounce quitam. I think a product of both of us getting a Jesuit secondary education in a certain generation. But it was always rewarding and challenging to cross swords with him. And it was always fun to hang out with him. So those of you who, like me, will greatly miss Jack. I look forward to getting together and sharing Jack Basie's stories with you in the years to come, when I hope we are doing these conferences in person once again. So my condolences go out to Darlene and to the extended Basie family. Our panelists today are Teigue Carroll, Bureau Chief of the Taxpayer Protection Bureau of the New York Attorney General's Office. Teigue's bureau is responsible for all enforcement activity in the false claims arena other than Medicaid cases. Do I have that right, Teigue?
You do.
Kathy Von Hoene, who is the director of the Florida Medicaid Fraud Control Unit. Kathy is also a longtime member of the Global Case Committee of the National Association of Medicaid Fraud Control Units, and is a national leader in Medicaid fraud enforcement, and particularly an expert in the area of managed care. Nick Paul is Supervising Deputy Attorney General for the California Medicaid Fraud Control Unit. He is a longtime co-chair of the Global Case Committee for the National Association of Medicaid Fraud Control Units, and is, I think it's fair to say, the dean of the state false claims bar. Before we begin our substantive discussion, I will point out, to save our panelists the trouble of doing so, that they are here in their personal capacities and do not speak for their respective attorneys general or the attorney general offices in their states. So before we talk about the substance of false claims enforcement, I thought it might be of interest to our audience to hear from all of you about the effect that the pandemic and working under these conditions has had on your offices in terms of resources and priorities, in terms of how you go about doing your work, Um, uh, can we start, Teigue, maybe start with you?
Thank you. First, let me give a brief chorus of thanks to everyone who's involved in putting this on. These are they go so smoothly, but there's a titanic technical effort involved, and really want to thank the staff of the ABA who are working behind the scenes so hard to put this on and put it on smoothly. So thank you to them. I'd also like to thank our moderator, Mr. Patton. It's a pleasure to be here and on this panel. And I appreciate your work in herding the cats, as it were. And then lastly, I'd just like to say thank you to all my distinguished colleagues. It really is a very flattering thing to be included in this bunch. So with that, I'll turn briefly to New York. On the pandemic front, as you all know, in March of this year, New York sort of faced a flood of cases, and there was a great deal of doubt and uncertainty, which the office grappled with just like everyone else. They did it well in this respect. They shut down the office, but everyone already had laptops. All of the lawyers were able to go home and use their laptops to communicate and continue with their work in a fashion relatively similar to what they'd been doing beforehand. There were lots of daily differences, like, for example, the ergonomic problems that you face when you have to sit on a milk crate for a month and a half or whatever it is. But in terms of false claims, I operated from led the bureau that I administer for 3 months virtually, doing things like this. Issuing subpoenas, communicating with defense counsel via email, as we always have done, having conference calls. We've conducted depositions using software that permits those kinds of things. There have been wrinkles like, what do we do with exhibits that we don't want to share and things like that. There are technical solutions to those kinds of problems. But in general, I was surprised to see how well the unit and the defense bar, frankly, adapted to the challenges that the pandemic brought about. One thing substantively that did change is our unit began to do, as Robert mentioned, we do non-Medicaid false claims, so procurement is a big deal for us. And one of the things that became immediately apparent is that there were going to be False Claims Act investigations arising from the really shameful attempts to cash in on the pandemic from suppliers of various kinds of supplies that need to be, that people need to use to combat the pandemic, like masks, personal protective equipment, ventilators, and the like. So we formed a sort of a subcommittee to deal with those. We drew from other places in the office and began investigating those sorts of things in combination with other entities in the state government.
Thanks, Teigue. How about you, Kathy?
Good afternoon. So in Florida, we were able to keep a lot of our core employees staffing the 8 offices around the state of Florida. Although we do have big cities in Florida, we also have some rural areas as well. And so we were able to rotate our headquarters staff as well as some essential, both law enforcement staff on the criminal side, criminal prosecutors, and the civil side to man those offices. And then we had several people, of course, that were working remotely from home. On the civil side, we're used to dealing with moving our cases along in a remote fashion through conference calls, et cetera. So not so much FaceTime. The more complicated issue was dealing with the analyst support that we do because of our connections with the Medicaid claims data and interacting with the managed care organizations and their special investigative units. So given the cooperation necessary in that category, we sometimes had a little bit of a delay in the data analysis, but that's only trying to get people together in a secure connection and to also safeguard everything for HIPAA purposes. On the criminal side, We still had some arrests during the pandemic. Obviously, there were some restrictions due to the restrictions with the courts in Florida, grand jury processes being on hold, and even the jails not wanting to take people in for purposes of contamination. So some of those enforcement efforts on the criminal side have been somewhat stalled, but we're back open. The courts are back open in a lot of areas in Florida. And the most important thing is to keep our staff safe. And we too had the burden of trying to shop judiciously and effectively without getting ripped off for the PPE supplies for our law enforcement staff that would have to respond. And in Florida, it's not only an issue of responding on a daily basis for our normal fraud and patient abuse, neglect, and exploitation work, but it's also to be able to respond in terms of hurricanes. And luckily for us, we only had one hurricane hit Florida during this past season. So we're lucky with that regard, and we didn't have any loss of life connected with that storm. But otherwise, we've been able to move forward in a pretty efficient fashion. We're happy about that. Thanks.
How about the Golden State, Nick?
Well, out in California, I think the priority for the state Medicaid fraud unit, not surprisingly, has been events in nursing homes and patient safety. That is by far and away the area of greatest sort of immediate focus, and has been for some time. And I don't think California is unique in that respect. From a KETAM perspective, we are seeing in California, and I'm sure this is true in other states, the first few cases involving allegations of exploiting COVID funding and federal largesse in particular for that, but some state money as well, in terms of fraud allegations in connection with exploiting that, both in a nursing home context and in other arenas. I think, perversely enough, in some ways, work is easier in the sense I'm thinking of interviewing individuals. There's just a lot more flexibility when everybody is right there by their computer, assuming your internet is working. I think we've gotten a lot more fluid in setting up some events compared to pre-pandemic days. But obviously that depends on whether or not your internet is working effectively. I think data analysis is always a key area in any Medicaid case, particularly KETAM cases, and it's an area that is sort of become prominent in terms of your ability to access the data remotely, depending on who you are and where you are in your state, and what your Excel skills are and other tech skills. And I think we've all navigated ways to work around problems in that area, but being able to work with your data analyst in your own state and those in other states is more important now than ever, and in particular developing a facility for working with our federal colleagues and their data platforms has never been more important. Some investigations are very difficult. Obviously, it's not really feasible to get into nursing homes on the basis that used to be sort of de rigueur before the pandemic. So those are a few initial thoughts.
Thanks all. Teigue, so get us started, please. If you could talk a little bit about the work of your unit in the New York Attorney General's office. I understand that you do a significant amount of procurement fraud, but in particular, I think our audience would like to hear about the tax fraud enforcement efforts that you folks have undertaken.
I'd be delighted. Thank you. This part of the presentation is understanding the tax provisions of the New York FCA. It is a relatively unique provision. There are a couple of other states that have them. Illinois is one. But in New York, they have become increasingly prominent. And we've had some really big number cases, settlements, and also cases that claim big numbers, which they're by no means big compared to the my colleagues' type of cases, but they are very significant for tax enforcement. And I'd start by saying that this provision is controversial. Many people don't like it. The defense has plenty to say about how bad it is. I think it's a very good provision, and it may be because of where I'm sitting, but it is a very effective complement, not a replacement, but a very effective complement to tax enforcement. And the reason for that is it goes much, much further than a mere audit can do. And there are plenty of safeguards which permit this law to be administered in a in an effective way without hampering the usual tax administration or interfering with legitimate tax disputes that taxpayers have every day with the authorities. So with that sort of preface, I'll turn to the law itself. If you want to look it up, the text is in your materials, so you have it there, but its place in New York's laws is here at the section on your screen, New York State Finance Law 87 through 94. And very briefly, it empowers the AG to bring a civil action. It has the key tam component. I use key, even though I had years of Latin education as well, because somebody once told me if you don't pronounce it the way everyone else does, they'll think you don't know what you're talking about. So I'll say key tam, and that extends to the tax provision. So a private individual can sue on behalf of the state of New York to redress a violation of tax law. A violation of the False Claims Act, which is made in connection with the tax law. So, what are the tax provisions? Well, they're the reverse false claim, right? They really are. That's the world we operate in, because you're not billing the government. You're saying, hey, I owe you less than I really do. And as in other statutes, we have three types of reverse false claim, put broadly. We have the false record of statement, which is the G claim. We have the D claim, which is possession of property or money used by the state, and less is delivered than should be. And then we have H, which is the classic knowingly conceals or knowingly and improperly avoids or decreases an obligation to pay or transmit money. That one is, of course, the best one. But in the negotiations leading up to the enactment of this provision, it was dropped from the tax provisions. In other words, it does not apply to violations of the FCA that concern tax violations. And the reason for that, we speculate, it was before my time, we speculate was that it was just it would have made things in the opponent's view, or the opponents of the bill, too easy for the state. So what we do have, and the primary one we use, is really the G claim, which is the false record of statement that's material to an obligation to pay. And so you can see that that means we have to, we've got knowingly, we've got, I'm going to go back. If you go back one, Robert, you'll see it there at the bottom. You got knowingly, you have falsity, you have materiality, you have to have the obligation to pay and transmit money to the government. So those are the basic provisions. It's an interesting, an elegant way this became, this came to be in existence. They simply struck the not, which you find in the federal provision. This is slide 15, Robert. It says this section shall apply to claims, records, or statements. There was a not in between the shall and the apply on the federal side. And the author said, well, we just strike that out. That is not enough. Going to the next slide. I'm going to skip the conspiracy. It's conspiracy. You've got it in other False Claims Act violations. We haven't used it yet. It's an interesting point. But I'd be happy to talk to people offline or answer questions on that. But in the interest of time, I'm going to move to the slide, exactly this slide, which is the monetary threshold. This was an important feature of the law because it prevents the kind of concern, or it addresses the concern of the law's opponents that, a tax violation. What are you kidding me? Every Tom, Dick, and Harry is going to have a potential False Claims Act liability because they cheated on their income, from $10 up. This provision was put in to avoid that problem, and it has successfully done its job. There's a twofold threshold, as you can see here. First of all, the person who's allegedly committed the violation has to have either a minimum of $1 million net income or sales. Person can be a company, of course, can be an individual. And the damages pleaded have to exceed $350,000. The damages can be aggregated, but you can't aggregate years to get that $1 million. It has to be $1 million a year or more. And let me just stop here and say that our experience has been the opposite of what was feared. Our experience has been that the cases coming in are considerably more than this. It's not $1 million. There's 2, 3, 4, 5, 50. Lots and lots of money coming in. Major corporations or very, very high net worth individuals who are typically at issue here, or who are named in the key TAM actions that we see. $350,000 likewise is a number we almost never see. It's always going to be more than that, in the single millions at a minimum, and more. So there's the threshold. I'm going to go now to. We can skip over the next one, which is the H claim we talked about. And I'm also going to skip over some slides here, which this is 18 and 19, which talk about the liaison and the sort of prohibitions which address, which safeguard basically responsible administration, responsible use of the tax provisions. And basically what they say is you got to talk to the tax authorities. You have to, if you're a private plaintiff and you want to get discovery from the tax department, you have to get the AG's permission. And those are designed, just in brief, to prevent any kind of interference with tax administration and to prevent abuse of the law, which we are very concerned, obviously, to do. I'm going to go to the next slide here, which is the leading case. This one you can look up. I think it's also in the materials. I just want to make a few salient points here. It came to the Court of Appeals, which is our highest court, on a motion to dismiss, and the denial of that motion to dismiss was affirmed. The points that are of interest to the practitioner here, I think, are the following. First of all, you got to have a tax violation, right? The False Claims Act, if you don't have a violation of the tax law, you can't have a violation of the False Claims Act based on the tax law. In the Sprint case, the question was whether the tax law was ambiguous, such that, a good faith position that the tax wasn't due certainly excluded any kind of False Claims Act liability. We thought that it was pretty clearly unambiguous, and the Court of Appeals agreed with us, as did the lower court who denied the motion to dismiss. But that was one of the arguments the defense made. They said, wait a minute, this was confusing. We tried to do our best. That's effectively a scienter argument, right? And that was really at the heart of this case, and it's often at the heart of these types of cases. We didn't intend to violate the tax law or the False Claims Act law. We did our best to understand the statute. We took a good faith position on our tax liability, and that's it. And so there's no scienter here. So the Court of Appeals had some interesting things to say about that. In the Sprint case, the defense they advanced a reasonable interpretation of the law, and said, look, it could have been this, right? And the court said, well, that's all very well, but it wasn't alleged that it was alleged that you didn't have that interpretation at the time you made the false statement or record. And so on a motion to dismiss, you're out on that argument. Certainly, as the court went on to say, in the last bullet here, the FCA is not to be applied in every case where taxes weren't paid. You have to have a fraud within the meaning of the False Claims Act. That's been very clear since day one. That's very clear to us. And that is kind of where I want to leave you on the slides. What I want to say very briefly to conclude is people say, well, have any of the problems occurred that people feared? Interference with the tax administration, hassling good faith taxpayers who just took an aggressive tax position, uncontrolled, opportunistic litigation, which will sink good, well-meaning businesses with cost. And the answer to that is that we have not seen those things happen. It's not that they were unreasonable concerns; they were extremely reasonable concerns. It's just that after 10 years of the statute's existence, we have not seen the kinds of abuses that were feared, and that's a good thing. And it's also a testament to the law's design. I'm going to stop with the last remark that if you want to look in some detail at the kinds of experience we've had, you can check the letter that Tish James, the current Attorney General of the state of New York, wrote to Mr. Becerra, who's the AG in California, talking about the history of the Act for its first 10 years and the kinds of things we've accomplished and the kinds of experiences we've had with respect to the fears that the law's critics have advanced.
A couple of follow-up questions for you, Teigue, if you don't mind. Can you talk a little bit about where your cases come from? Are they the tax cases primarily whistleblower originated? Are they referrals from the state tax authorities? Combination?
That's it's a good question. The answer is that the majority of the tax cases we get come from whistleblowers, and that those whistleblowers can be loosely categorized into two groups. One is industry professionals who discover from the outside that something is wrong because they know how the industry works, and they say, wait a minute, this guy's revenues should be less, or I've checked these bills out on this, and there seems to be the sales tax is wrongly calculated, that sort of thing. And then there are the true blue whistleblowers who say, geez, I worked at this company for 10 years, and the new CFO came in, and all of a sudden we weren't counting a bunch of income that was coming in, and I didn't like it, so I told him that it was wrong, and he fired me. There's that sort of thing. But just looking at the entire group of tax claims that comes into the office or how we get them, the vast majority are key TAM relators, whether they be industry experts who are the minority or true whistleblowers, as we would term them. Does that answer your question? I think I got it.
So both in the time that I was an assistant attorney general in Massachusetts and during my time with Taxpayers Against Fraud, I had occasion to consult with states that were either considering enacting a False Claims Act or amending their False Claims Acts. And based on the experience of your unit in the New York AG's office, I came to the conclusion that it was important to offer the New York False Claims Act as a good model for the very reason that it does provide this important source of potential enforcement, potential revenue for the state. And a question that often occurred to me, I thought I might ask your thoughts on this. When smaller states, the District of Columbia is also considering enacting a provision. Smaller states, perhaps on the scale of Vermont or Montana, are considering an enactment. It sounds like the thresholds are important as a safeguard against abusive litigation and clogging up the courts, but perhaps one size does not fit all, and a smaller jurisdiction might consider different thresholds. What are your thoughts on that?
I couldn't agree more. You're right. It's not one size fits all, and the threshold, I think, is an area where, look, I mean, I think scienter is probably one size fits all, right? You have to have, one of the three types of scienter, but a threshold really does depend on what the law's framers are trying to get at. If there's if nobody will meet this threshold, then the law is a waste of time, because you'll never have anyone to enforce it against. So it would, I think, that provision would benefit extremely from a sort of thoughtful study of what the tax base is, what kinds of taxpayers there are, what the tax abuses most widely seen are. Another potentially adjustable feature of the law is, should it apply to all kinds of tax, or should it be sales tax only? Should it be income tax and sales tax? Any violation? My own view is it should be as broad as possible there. But there may be reasons why a state might say, well, it should only be sales tax, because that's where we think we have the biggest problem. Or we don't want to discourage high income people, or we think our safeguards on the tax side are most effective, or are effective already. It may be a way to compromise with the law's opponents.
And then one more question for you, Teigue. That is, when I have provided the New York False Claims Act to folks from other states who are considering either enacting or amending a statute, I note that within the four corners of the statute, you don't have CID provisions, which I consider to be a very important and powerful tool for government enforcers in this area. I understand, though, that the New York Attorney General's office has access to similar provisions through other statutes. Is that correct?
That's right. We have Executive Law 6312. We also have the provisions you mentioned are in our regs. But we also have Executive Law 6312, which is New York's general purpose fraud statute, which we administer, and that affords us subpoena power. And I'll just say in that connection, subpoena power is the chief investigative tool that makes this kind of law important as an adjunct to tax fraud enforcement, because the auditor, as I said at the beginning of my presentation, checks the arithmetic, and the auditor is not shown and does not know and is not empowered to get the whole picture, and never is. And so one of the common defenses we hear is, well, we were audited, everything's fine. And then we say, okay, well, let's see your emails from that time. And the emails all say, well, don't show the auditor anything, don't show them that, don't show them this. It's important not to show them the other thing. So subpoena power is vital. New York City does not have it in their False Claims Act. They do have a DOI, but that's proven an obstacle, and they come to us often to work jointly because of that problem. So it's vital to have it. There's no question.
Thank you, Teigue. Nick, turning to the topic of Medicaid fraud investigation and enforcement, could you talk a little bit about the role of the states and the Medicaid fraud control units in particular, both with respect to state-specific matters and to healthcare investigations that are national in scope and have a Medicaid component?
Sure, and we can jump to slide 21 as part of this. The National Association of Medicaid Fraud Units, or NAMFUCU, is an association that was founded in 1978, and they're now Medicaid fraud units in all 50 states, plus DC and Puerto Rico and the Virgin Islands. And the general purpose of what the states do on a day-to-day basis, and the context for this is essentially that of how to go after, how to effectively work together in prosecuting QTAMs that are filed on behalf of the states that have a False Claims Act, and that's about 30 states. And the purpose is to afford a mechanism to coordinate the efforts of the states, working, of course, with our colleagues in the federal government, and managing the competing tensions, if you will, that arise from the fact that you've got up to 30 sovereign states named along with the federal government and perhaps other political subdivisions, which sort of gets at the point that got with this slide here in terms of appreciating the roles of the real parties and interests. The federal government is understandably always the big dog in the room because many of the allegations that are pled in a qui tam necessarily implicate Medicare as well as Medicaid and of course, other federal programs such as TRICARE and the VA and a few other programs. You've got multiple states, and if you have 30 states named, you've got 30 different sovereign perspectives automatically implicated as soon as they're all named. And the states don't look at the issues in a uniform way. They are all sovereign actors, and they've each got their own sovereign Medicaid fraud units with their own obligations to their AG and other state constituencies. And they also have to work with their own state agencies, which is easier done in some states than others. The non-qui tam states, in other words, states that don't have a False Claims Act and therefore are not named by relators, are also a key facet of what any NAMFUCU team attempts to coordinate because they've got an interest here, and most defendants are going to want to achieve a degree of global peace because they're still liable from a common law fraud or other fraud theory perspectives, even if not under a False Claims Act that doesn't exist in those 20-some states. So those other states are vital to the effort that I'm describing. They all contribute to the process in terms of the teams that are established under the auspices of NAMFUCU. They're key players, and this effort proceeds apace in an effort to achieve a recovery for all states, regardless of their size and regardless of whether or not they happen to have a False Claims Act statute. Some of the 30 states that I mentioned that do have a False Claims Act have a general act, as in New York and California and other states, and some have a False Claims Act that is specifically tailored to only Medicaid fraud. Lastly, there are various political subdivisions around the country that have their own False Claims Act statutes, such as New York City, Chicago, and a number of political subdivisions in California. And in California, the California Department of Insurance, like the Illinois Department of Insurance, has its own False Claims Act mechanism, which enables relators to name the state under the auspices of insurance fraud committed at the expense of commercial carriers. So all of those entities need to be coordinated, and that's sometimes something of a juggling act, but it's important to recognize the various perspectives that are represented in those 4 bullets there. So Kathy, I think you were going to talk a little bit about nuts and bolts of first to file.
Yes, if we can go to the next slide. So when we're talking about state FCA enforcement, a lot of it starts obviously with the qui tam complaint and disclosure materials that are provided both to the United States and to the named plaintiff states and any named political subdivisions. And remember that in the state False Claims Act enforcement world, most of our complaints come from whistleblowers. So we look at these materials very carefully. And the case that's cited there is an example where the relator spent more time litigating who was first to file than what really happened with the underlying investigation of the fraud that was being alleged against Millennium Labs. And the reason why I cite to this case is to just make sure that for those that are representing relators, those whistleblowers, you really need to know the case law in the circuit in which you're filing so you can understand what's going to happen not only at the initial phase of the process as to how the Department of Justice and the U.S. Attorney's offices in that circuit that you're dealing with are going to handle the incoming materials, but also what could happen down the road if there is a dispute later on as to what is looked at to determine who is first to file, if there's more than one relator involved. So in this particular case, the First Circuit basically was looking at the various complaints that were filed and looking at the substance of the allegations in the complaint. And of course, all fraud complaints need to be pled with particularity. But when somebody is actually filing a complaint to determine first to file, it is really an issue to see what was in the complaint, who filed it first, was it the specific facts of the fraud that was actually the fraud that was investigated, that was intervened on by the government or that was the basis of the settlement by the government. And here, if you read that case closely, it goes down into the weeds about why there is such a distinction between the various relators that filed. So again, a lot of thought and detail has to go into the complaints and those disclosure materials to garner the attention of the various states as well as the federal government. And you can go to the next slide.
We thought we'd just touch on a few points which are probably obvious to many of us listening to this, but in particular, I guess for our colleagues in the relator bar, that there do seem to be a steady, tiny percentage, but nonetheless a percentage of cases every year that do involve tainted materials, and that does jam up the gears when you get a case involving that, because you've simply got to put a brake on it and quarantine everything, if that's the right word these days, segregate everything, and make sure that no applicable privileges are violated, because that gets the case off to a very rocky start. So that's the key don't. The other two are do's. Specificity and particularity are required under the federal rules, under 9B, but they're also required if you want to get the government's interest from a practical perspective. The more detail that you can provide firsthand, obviously, the better off the more attention your case is going to attract, I think, from the outset. One last nut and bolt item to mention here, because it does arise regularly, is I mentioned the 30 different states that have False Claims Acts, and they've all got their own service requirements, and some states are quite insistent that service be effectuated in conformity with what their statute requires. And this can be a real problem when it comes time to resolve a case and put together a settlement. If the state believes it was never properly served, that implicates the relator's interest quite directly. So, on to the next slide.
Okay, so we list both the public disclosure bar and original source. It's a very lengthy topic, so we're not going to go into great detail. This is just an example of a case where it was hospice services, again, being rendered for ineligible patients. And there was a public disclosure bar issue because of a prior unsealed key tam against the same corporate parent and basically the same type of fraud scheme. You're trying to get people into hospice that didn't really qualify for hospice. But it's an interesting case, obviously, from 2020, but it does show the difference between the based on language versus substantially the same language after the amendment that took place March of 2010. So it's an interesting read just to get into the weeds on it. But it's important that if you think there is some kind of public disclosure issue, if you are representing a relator, then you need to read carefully through the cases about whether or not your relator could still qualify as an original source in order to avoid being barred under the public disclosure case law. Let me go to the next case. Next slide. Okay, 9B particularity. Again, this is a matter of where are you when you file. So this is a case from the Middle District of Florida, which is within the 11th Circuit Court of Appeals. And in the 11th Circuit, you really need to come forward in your complaint identifying the submission of the false claim. And oftentimes that can be achieved by including billing data that's in the allegations in the complaint. It could also be representative sample false claims that are associated with the fraud scheme that's in there. Or you may have a relator who has the particular subject matter knowledge because of their unique position while they were employed with the particular defendant, so that they know that the claim submission process was submitted. And so the 11th Circuit is very stringent on that pleading requirement. Some other circuits aren't quite so good, but when we're trying to connect the dots between the false statements or false records or the submission of the false claim or what caused the submission of the false claim, it is always good to have some billing data or claims data that you can look to. Otherwise, you're going to be missing an element later on about whether or not you can draw a causal connection that lends to the loss that the Medicaid program has sustained. And particularly when you're filing, if you're filing and your relator only knows about Medicare, it would behoove you to do some research about the various Medicaid programs for those named key TAM states whose claims you want to submit on behalf of. Because if you don't have that level of detail or that understanding about how that Medicaid program actually reimburses for the goods or services that are at issue, you could find yourself being dismissed later on for not enough particularity. Next slide. So this is a case out of the 11th Circuit, and this was a case where there was a jury verdict for a large amount of money against a nursing home, and there was both a Medicare fraud claim as well as a Medicaid fraud claim. It was a decline case. It was litigated by the relators. The district court judge set aside the jury verdict in its entirety and gave judgment for the defense, and it went up on appeal. And the 11th Circuit reversed the district court for having overturned the jury verdict when it came to the Medicare fraud case, which dealt with upcoding and ramping up to support inflated RUG scores for therapy charges. However, the 11th Circuit did uphold the district court judge for overturning the $30 million Medicaid fraud judgment based on a jury verdict. And what the court said there, that in this particular decline case, there wasn't enough evidence presented by the Relators Council because all they were able to say was that there was a lack of care plans for the residents at the nursing home. And there wasn't much more in terms of materiality evidence beyond the fact that care plans were a condition of payment under the Medicaid regulations. But the important thing here is that in that trial, they had expert witnesses saying, oh, of course, care plans, they're essential. You know, they're part of the main premise of Medicaid. But they had no single state agency witness. They had no witness from the Florida Medicaid agency, which is the agency for healthcare administration. They had no witnesses from the Medicaid managed care organizations that run the long-term care plans on the managed care side of the house for long-term care enrollees. And they didn't really set forth any kind of theory by the Medicaid program about how essential care plans are. And so another tactic that could be used going forward, of course, would be not only to get a single state agency witness, but a CMS witness, because the state Medicaid regulations follow the federal regulations, and care plans are really the essential of the essence of the bargain in the Medicaid space. The care plans are basically the constitutional foundation for delivery of care to the vulnerable seniors in those long-term care facilities. It establishes the individualized needs assessments, which of course lends then to medical necessity. And of course, some of those arguments weren't made in this case, but there are things that could be done, again, if you delve into the details of the Medicaid program and the claims you're trying to make and do the research ahead of time and obtain the witness testimony that you need, there could have been a different outcome in that situation. So the next slide, please. And another basis that the 11th Circuit, had upheld the district court overturning the Medicaid fraud judgment was that there was a theory of an implied certification theory of liability. So they said there wasn't enough about the goods and services being delivered. There was no critique about a lack of efficient services that were being delivered to the nursing home residents. And it said there wasn't anything about the claim itself that made a comment about the goods or services. But again, looking at this case and trying to think about how the case could proceed in a similar case going forward, I would caution everybody that there are many, many express certifications of you can find in state Medicaid programs. So instead of relying on an implied certification theory of liability, it's very possible when you're pursuing fraud with the state Medicaid programs to use express certification theories. And those express certifications start anywhere from the Medicaid provider agreements with the single state agency, provider agreements with the Medicaid managed care organizations, and you'll see the express certifications also applying in on the electronic claim submission process, your CMS 1500, UBO4s, any kind of version of those. You'll also see those express certifications that you can find in the electronic funds transfer agreement. So when you're following the money to the pay-to provider, it's going to say, we understand we're drawing down federal and state dollars, and if we make any material omissions or misrepresentations, that we can be prosecuted, et cetera, et cetera. So there's lots of different language that can be used And again, the important thing is if you're going to show materiality and you're going to go with an express certification theory of liability, it's always good to line up witnesses both from the fee-for-service side of the house as well as the managed care side of the house. And I would commend everybody to look at the ABA Virtual Institute session that was done specifically on Medicaid managed care, and I believe it was recorded on November 17th, 2020. So for more details on Medicaid managed care, I would encourage everybody to review that recording and contact the ABA to get assistance with that. Next slide, please.
So we thought we'd make a few points here, subject to any questions that Bob may be pitching our way, some nut and bolt issues, turning away from the careful case law that Kathy's been explaining to us. First, just the topic of preparing a relator for a government interview is obviously critical to getting a case off to a good start. Data is the heart and soul, as has been said earlier, of any Medicaid case, especially one that involves multiple states, along with the Medicare data, of course, is going to intersect with it as well. The more of an understanding a relator can bring to that, and an understanding of the key data sources that underpin the case, the better off the initial interview is going to be. A careful knowledge of witnesses who can support the allegations if the relator is weak in any particular area, but has an understanding of who else within the organization might have some knowledge about this, prior employees, what people are doing now, contact information. All of this can save a lot of time and effort if it's readily available. Having participated in several relator interviews during the pandemic, I think sometimes when the attorney is in one location and the relator or the QTAM plaintiff is in another, it really does pay to carefully prepare that before the interview, so you're not stuck with a situation in which you've got a bad connection or a relator who's not prepared to go forward. One thing worth bearing in mind is the fact that when 30 states are named because they've all got a False Claims Act, perhaps because counsel feels that's required from a due diligence perspective, there does need to be at least some sort of an answer for a state that's going to ask, well, how was my program affected? There's some types of fraud that are, the classic example is off-label fraud on the part of the pharmaceutical manufacturer. Well, it's fairly self-evident usually how that impacts every state nationwide. But there are other types of fraud that are going to require some thinking about how are you going to answer that question? Because if you name a state, you're going to have to, I think, have some sort of support for that. Getting a relator ready for an interview also requires coordination amongst the states, obviously, but also requires some coordination from time to time with the other subdivisions that may have been named by counsel, such as in California, the Department of Insurance, for instance, or if a city has been named. It's not the job of the team of attorneys who are representing the interest of the states under the auspices of NAMFUGO to reach out to those other entities, but they are out there, and having been named, it can represent complications further down the pike if they charge ahead with their own investigation because no one from the relator side has reached out to them in an effort to try to get the left hand and the right hand to talk to each other. Turning to the next slide, I think Kathy's already made the point about the importance of managed care, and she's referred us to an earlier presentation that was an outstanding presentation put together in part by one of the attorneys in her office. Medicare is, Medicaid managed care represents about 80% or so nationwide of the Medicaid program, and in some states it's a higher percentage than that. In California, it's about 80%. And that represents real challenges in some types of cases where the underlying service that's at issue was primarily provided under through the mechanism of Medicaid managed care delivery. It's an area of robust discussion with our federal colleagues as to how you measure damages and how you establish materiality. And I think it's safe to say it's not been resolved at this point, but that issue is here to stay. So it merits consideration early on in a case. And lastly, never forget the old adage that when you see one state Medicaid program, you've seen one state Medicaid program and no more. Turning to the next bullet, just to recognize the importance of the NAMFUGU intake teams, and I know that, or at least I think I saw their names, Sarah Van and Candace Desher from Georgia and Virginia respectively are the co-chairs of the KTAM subcommittee within NAMFUGU, and they do a truly outstanding job of running on a day-to-day basis the coordination effort between the states that goes on to manage state activity in all of these cases. I think the California case load right now is around 390 or so cases in which we're named, and I think in the vast majority of those, other states are named as well. So this is a real day-to-day coordination effort, and it's the intake team that manages the state's interest in the relator interview that I mentioned earlier. And it's just worth a shout out to their efforts on a day-to-day basis, because that intake team is to effectively work with our federal colleagues in US DOJ and DC, as well as the US Attorney's Office, along with coordinating the problems that can arise from the need to bear in mind the interest of other subdivisions who are brought in by the relator having been named. Lastly, the point I'd make on slide 31 is that subpoena power varies among the states. Teige's already commented on the importance of subpoena power in New York and the various tools that are there. Those tools are not uniformly shared amongst the states. The federal government obviously has a robust subpoena power, and many times the states frankly rely on that, at least initially, to kick the door down, so to speak. But a number of states do have a robust subpoena authority, and it's an area where particularly once an investigation gets moving full bore, in where the resources of the various states that are leading the investigation as to whether or not they've got that authority plays a key role. So I think maybe we'll skip ahead to slide 33 in the interest of time, where Kathy is going to talk a little bit about a couple of other key considerations.
So I've touched on it slightly already, but as you get ready to go forward in litigation, that intervention decision has been made. That's where everybody really needs to put forth their best foot and say, what can I bring to the table? And what you have to remember is when it comes to the damages and the data, a lot of the Medicaid fraud control units, they don't own the data. It's usually in the hands of the single state agency. So there are times even when the Medicaid fraud control units will go forward and intervene in litigation where they're still doing friendly subpoenas over to the single state agency to get that level of detail from the single state agency for data to prove up the case. And again, as we stated previously, it used to be just single state agency witnesses, but now we're talking about managed care witnesses as well. In terms of the scienter, another thing that you need to be careful of when you're in litigation that will always become a discovery issue is who knew what when. Was it the single state agency that knew something? Was it with the AG's office that knew something? Was it the governor's office? Who knew what when? And so there's lots of interesting discovery issues to be ready for in that situation. When it comes to the Medicaid claims process and the billing process, I would encourage you to make sure that you know how the money flows through the system, especially if you're dealing with a federal case, especially if there's a possibility of a criminal case going forward, as well as your civil case going forward, because oftentimes that flow of the money can trigger wire fraud charges because of the way money flows out of state from an outside state into a state for a Medicaid program. Next slide. And again, when you're cooperating in the settlement process, just remember it is the government who's the real party in interest. It's the government money that's been lost due to fraud, whether it's fee for service or managed care. And that in the settlement process, as Nick has previously described, a lot of times the defendants want global peace. So they're going to want to have a settlement not only with the named key TAM states, but also the non-named non-key TAM states. And then when it comes to the damages methodology, oftentimes in the settlement process, it's double damages with litigation risk factor applied. It's not necessarily treble damages and civil penalties, and those are very rare. And those are reserved from when somebody actually rolls the dice to go through litigation to see if they get a judgment against them, which will exclude them from the government healthcare programs. So that's why it's a good incentive for the defendants to settle. And of course, under the Tax Act, since we started with tax, as we're closing up here, we'll be going to tax again. You need to indicate what a part of the recovery is your restitution amount. And we're running out of time, so I'll just tell you for the remaining slides, they're the further slides that go in and address those issues. Well, what is a fair, adequate, and reasonable settlement? And so if you go to the next slide, and so there's a case on that for you. The next slide is relator share and multiple relators, how you decide who was first to file, and also what was at stake. And then the next slide for relators' attorney's fees. Next slide. For the relators' attorney's fees and costs, it's a reminder to everybody that even if you get an agreement between certain relators that they're going to share in the relator share, that doesn't mean that these other relators that are not first to file, that they get attorney's fees and costs. They're not going to get that. So that's a cautionary tale for those on the back end of the case. And there's a couple of slides that deal with it as to how it's addressed in the settlement agreement and the statutory provisions.
So, Nick, a quick point of clarification when you talked about the extent to which the Medicaid program in California is managed care. The figure you used was 80%. Is that right? Not 8.
I'm sorry. Yeah, that should have come out of my lips as 80.
Okay, thanks. And to our audience, we, as expected, got to most but not all of the topics identified in the materials. The panelists have been kind enough to say, and I say it too, that if there's anything else that we can help with, our contact information is in the materials. Feel free to reach out to us. Thanks to the ABA and the Criminal Justice Section to make this conference possible, to Sarah, Lisa, and Rick, the coordinators, and we thank you all for your time.